And then the last case I wanted to bring up is Legendary Builders Corp. Versus Grovewood Properties. This is out of the 2nd District, 4th Division. It's an unpublished decision. We actually talked about this one before, but I'm still boggling at it. It's a statement of decision case. The trial judge omitted making making findings on certain material issues from the statement of decision. And the appellant did everything the appellant is supposed to do, requested the statement of decision, objected to the omissions in the statement of decision, and got the Court of Appeal to agree, yes, these are important material questions of fact that need to be included and you have a right to them. So reversed, but with directions to send it back down to the trial court to take a look at the record and just make the findings this time. And then when the appellant is not happy with it, then come back up on appeal. And then we'll reach the question of whether it's supported by substantial evidence. So I just think, what the heck good is that? Because I have always told clients and trial attorneys, the statement of decision process is so important. It can create such a powerful issue for appeal. Because if those important material issues are omitted, then you can get a reversal. But now, if this is the result to be expected, I got to ask, are you going to continue telling clients and trial counsel to go through the whole rigmarole of the statement of decision process, which is very cumbersome? It can tend to irk the judge. Or do you just skip it and go straight to the substantial evidence review on the implied findings on appeal?
Yeah, your advice to clients should continue. This is an outlier case. We read this and we talked about this a couple of weeks ago with Francis on the show. Yeah, this omitted issue is perplexing, and there's a story behind the story there. There's something, either it's result, outcome. There's some story behind the story.
Well, it's happened to me once before in the case you know about, and there was a story behind a story there too. But is it your experience that that in this situation, normally the Court of Appeal will reverse with instructions to do what then? To just do a new trial?
I cannot tell you that I've actually ever handled an appeal of a statement of decision issue in terms of the sufficiency or adequacy of the statement of decision. So
yeah, well, I don't know the answer to the question either. Like what I know what I think should happen, but I don't know what actually happens, other than I've seen this case and I've seen what happened to me in another one of my cases. So I'm gonna keep my eye out and see what other cases are doing, because if this is the norm, then I'm going to change my advice.
Well, I think we would argue that that's judgment in your favor, right? The judgment doesn't address everything it should address, but I guess in theory, it's like the statement of decision didn't address one of the legal issues or something else, or didn't do a statement of decision at all and was supposed to have done one. When that happens, they send it back to do a statement of decision, right?
Yeah, which just seems like a terrible waste of everyone's time. There is another case. There's a case that I cited when this happened in the briefing before this happened to me, when I was arguing that the absence of a statement of decision after the appellant has duly objected to that absence, when the trial court persists in failing to supply the missing finding, it leads to a reasonable inference the Court of Appeal should make that finding cannot be made on this record. And I asked the Court of Appeal to do that, didn't do it in my case, and obviously didn't do it in this case. But I guess that's the argument you have to make, that the Court of Appeal should make the finding that the finding cannot be made.